Okay, so today I'm going to talk about use of waivers and exculpatory clauses. So this means even though the organization employees or associated employee are responsible for mere negligence, however, they're trying to protect themselves from letting people signing in what? Waivers, which means I want you to give up all the right to sue us for mere negligence. So if you go to Disneyland, for example, then back of the ticket kind of indicates that all the responsibility or the mere negligence accident will be based on assumption risk. So we are not negligent, which means whatever will happen only for the mere negligence, then you will be responsible for your own injuries and distresses. So what do you think? Is it reasonable to do that? Organization automatically protected from these waivers? Yeah, I mean that's true. I want you to think about some emergency situation. You are in the surgery room, operation room, and your doctor said, a surgeon says, you need to sign this form, which means as a doctor, as a surgeon, if I make a mistake, not on purpose, but if it happens, then I want you to give up the right to sue me because I didn't have any intention to hurt you or fail in my surgery. Would you sign the form? No way. But in sports organization, I read some article, Korean newspaper, a couple weeks ago. And then the article talked about some of the potential danger and ignorance of the danger in automobile kind of mountain bikers, MTB. Right? MTB, mountain kind of bikers and some cruises. There is no safety lessons. There is no safety training. And then even though the participant do not fasten their seatbelt, and then the organization actually represented in the interview with the media says, we require every participant to sign the waiver form. So whatever happened to them, we are not responsible. So I want you to think about if waivers will be protected, then what's going to happen? If I'm the owner of some of the Disneyland theme park, I'm going to require every one of the participants to sign the form, and if they're injured or hurt, then I'm not responsible. I don't have to pay any for their injuries and some accident. So what do you think? Is it fair rules or something that doesn't make sense? Baseball, same thing. Back of the ticket, very small size of font indicate ABC 1, 2, 3, 4, which means organization or baseball team or stadium owner not responsible for your personal injuries. Yeah, I mean that's the recent trend, because if the court respect too much for waivers, then the organization is not going to do anything, because waiver protecting us. What do I have to do? My duty, list of duty, not necessary. Okay? So more and more organizations realize that the waivers not automatically protect the organization from the mere negligence. That's the new trend of the recent cases, which means the court warned that the organization trying to do their best to protect the participant and customers from potential dangers and injuries. Okay. So before I just jump into this area, I want to remind you what we covered last time. So what are the duties, 5 duties of premise liability? What are the 5 duties of premises owner? Number 1. Okay, duty to design the facility safely. That's number 1. If you do not meet any safety rules and regulations, which means that's the negligence per se. There must be some safety code you have to respect. Okay, there is guideline. Swimming pool, baseball stadiums, or classroom. Each construction should follow the governmental guidelines. So number 2. Okay, duty to provide immediate medical assistance. So we talked about AED, right? AED, automated external defibrillator, right? So if you open, it costs a lot of money, $2,000 to $3,000, and then if you open it, then it's not reusable. It's not usable. And then if you open it, okay. I heard that I talked to one of the employee in this building, and he said there's a one AED right next to the administration office. So if you open it, if somebody have a heart attack and you open it, and then you have to follow the instruction number 1, 2, 3. If you open it, then it has a GPS. So local hospital going to realize that there is some patient, and then the AED is utilized right now. So they're going to send their emergency at the 911 vehicle as soon as possible. But once you use it, and then it's not going to reusable. That's why some state cannot require all the sports, health, leisure, recreation related organization to have AED on the premises. Some of the small business owners, if I'm running very small size fitness club, how can I spend $2,000 or $3,000 for only one AED? Doesn't make sense. That's too much financial burden for small business owners. However, some state require, as long as your organization, your business related to sports, fitness, health, and leisure and recreation related, then you have to have AED. Because that was a kind of main case for that, the duty to provide immediate medical assistance. Okay, that's number 2. What about number 3? Another duty. What other duties? Duty to inspect. So I just brought up 2 notion, right? Legal notion. What is the first one? Actual notice and constructive notice. Actual notice, this is based on what you look at, what you inspected. What about constructive notice? What does that mean? Constructive notice. Okay, so this is about kind of a English statement. You would have been prevented. You would have prevented from ABC being injured if you did ABC. Does it make sense? So if you inspected this soccer field reasonably or logically, like 2 hours or 1 hour before the game start, then you would have been found that there was a hole made by burrowing animals. So we talked about Jim Morgan, right? James Morgan.
Then, if you inspect it and there's a hole, then is hole a actual notice, and the possibility of animal is the constructive notice?
So if you know the area on the field and then you know there's a lot of boring animals in that area, then your inspection should be reasonably scheduled. If you have a game at 6 p.m. tonight, but 9 a.m. inspection was not adequately scheduled. Okay. So if you inspect it at probably 3 p.m. or 4 p.m., you would have found that hole on the ground, not 9 a.m. because you are the owner or employee who knows the area, so you haven't done more creatively and reasonably because of foreseeability. Okay, Christina Behrman, the case. Behrman, Christina was a Notre Dame football fan, right? So she was actually, she saw groups of people actually drinking at the tailgating party at the parking lot. So she those same groups of people, and then before the game was over, she left the stadium because she didn't want to be too crowded. So she left maybe, let's say, like 10 minutes before the game's over. So she came back to the parking lot, but same groups of people drinking, same spot, more than 3 hours. So university or campus patrol said, there's no fighting when I patrolled. That's based on actual notice. There's no fighting, which means I didn't do anything. What do I do? However, if you see same groups of people drinking more than 3 hours at the same spot, then what would you foresee? Probably they will be drunken. So you'd have done it, you'd have cleared that location before people become crowded. Make sense? Okay, so what is number 4, another one? Duty to warn of hidden dangers, right? Duty to warn of hidden dangers. So you are the person who knows the area. So if you said this chair is broken, then you'd have a warn and put the warning sign. I just explained the examples of cleaning the floor at the restaurant, right? So wet floor. So you should have put some signages. 100%. Most of times, probably in the North America, you can see wet floor because that's what they were educated. Very important. Okay. And also another one, swimming pool. Open swimming pool. Put it, you have to say it. Lifeguard on duty from 9 a.m. to 5 p.m. clearly. Okay. If you do not put the sign, then there's a one drowned person, then they can file a claim against you as the owner of that swimming pool. But if you put the signages, then the people aware of that there's no lifeguard on duty during the off operation hours, then they will be responsible for their own injuries. Okay, what about, is there anyone? Okay, duty to design, duty to inspect, duty to warn of hidden danger, duty to provide the immediate medical assistance, and duty to repair. So that's the last one, duty to repair. Okay. So if you realize that if you recognize any potential problem within the organization, then you have to fix it in a timely manner. So I brought up that the case, one female fan actually split the soda on the bleacher seat, right? She was climbing on the bleacher, and the next person behind her to step on the soda, split the soda, and then she actually fell and hurt. So there is no time to fix it. So it's not reasonable. But if you see the problem and then one of the broken chairs, then you have to put the signages and you have to fix it in a timely manner, maybe next day or so. Okay. And then what are the 2 additional defensible options? So we talked about some defensible options for participant negligent cases in the first second weeks or so. Statute of limitation, right? Remember statute of limitation. Number 2, act of God, and assumption risk, and then immunities. Okay, immunities, and then contributory or competitive negligence. So we talked about 5 defensible options, and we added 2 more last week. The danger is open and obvious. That's another one. And then what about the last one? Recreational use status. Recreational use status. Because one of the female resident in Montana state, she was attacked by one of the bear, and she claimed against the Montana state because she says she's a public invitee. Public invitee, which means she paid for taxes. She paid taxes to Montana state. So she said the Montana state owe a duty of reasonable care to her. Okay. However, from the Montana state's perspective, there is no way to protect Rocky Mountain, the whole Rocky Mountain. They even don't know where the bears live, right? So it's not possible to hire thousands of employees, or there's no way to block all the mountains to protect people being attacked by wild animals. Good. Okay, and then I brought up some other important notion. What does that prior similar instance rule? Prior similar instance rules. I gave you a 5-page long Korean article that I wrote, right? So I think that Korean article also explain the prior similar instance rules. What does that mean?
So like if an incident happened and it happened again,
Yep.
then you should know that there is a danger because it happened before.
Yeah. So you should have taken some actions, or some disciplinary action, some anything to prevent the same or similar accident from happening. So there's a fighting at the baseball stadium, in the restroom, and in the right next to action number ABC, for example. Then what would you do? There's an accident. There's a fighting yesterday, and then you should have done something right away. You can hire more number of security personnel, or you can install more lighting system, so make it brighter, so people can see from a distance what's happening there. Or you can have some security camera. Okay, what about the baseball rule, or I can say limited duty rules? Limited duty rules. Limited duty rules is same as baseball rule. That's another key concept, key notion. Limited duty rules. So if you can, the PowerPoint slide, then you can see it. What does that indicate? Okay, so I mean that's a kind of an example, but what does that explain? Limited duty rule, which means as a stadium owner, especially for baseball, then there's no way the owner can install the safety net throughout the stadium. Okay, so owners will be protected due to the unique nature of the baseball game. So think about usually 2 major sports where the fan to be hurt: baseball and ice hockey. Football is okay, I can hit, but safer than baseball, being hit by baseball. And ice hockey puck, right? So ice hockey league actually installed on the glass protection right behind the goal post since 2003. However, Major League Baseball still, every 3 fans per 2 games hit by a foul ball or batted ball, or I can say the broken baseball bat particles. Okay. How can you protect fans to being hurt? Then people are asking, okay, you need to install the safety net. But some fans argue that I don't want to watch the baseball game through the net. That distracts my viewing, right? So we don't want it. So there's no way you can protect every single spectator at the baseball stadium. So that's why baseball stadium owners are lucky to be protected from mirror negligence, especially for the fans to be hit by foul balls and other particles. Okay, so use of waivers and exploratory clauses. So communicating with sports and recreational participant, something happened in terms of negligent issues occurred, then the waiver will be used as a secondary document. What you did, you have some class, rock climbing, bungee jumping, kind of a dangerous sport, or we can call it extreme sports. Then somebody hurt, then right away, okay, a lawsuit is expected. But what if you ask them to sign the exculpatory agreement or exculpatory clauses or waiver, we can say waiver form, then you will be protected. You are more likely to be protected. And also that document will be used as a secondary and supporting document for your organization as well as yourself. However, not always applicable. If you write the exculpatory clauses or waiver form in a good way, in a right context, then you might be protected. However, if you write the waiver form in a wrong way or in a wrong context, then their waiver form will be invalid. So I'm going to talk about what situation can make it usable and make it invalid. Okay, promotional materials. So if you want to work for the sports organization as a marketer or other managers, then you gotta be careful. Do not overestimate. Do not showcase how safe your organization will be or how safe the activity that you provide will be. Because nature of sports, there's no perfectly safe sports or recreation event. But some organization overuse perfectly or very safe, extremely safe. Those words are not helpful for your organization, just in case you have faced some legal issues. Okay, and then consult an attorney. So this is one of the great way. If you want to make sure your brochures, marketing brochures will be reasonably and logically and safely written, you can hire the attorney. Pay about $200 or $500 an hour, depending on the location. But you can ask them, hey, can you take a look at it? So make sure the content of waiver form is written correctly. Just in case somebody file a claim against you and your organization because of the failure of this content of waiver that you written, then you can have the attorney to be liable because we consulted the attorney and attorney said this is okay. So we 100% trusted our attorney, and if this waiver form is not correctly written, then not because of us, that because of my attorney. So you can file a claim against the attorney. Okay? So I'm going to share one of the extreme example, Sunday versus Stratton Corporation case. So novice skier, so you can read your own, I can give you like a 3-minute. Novice skier was seriously injured, and then keep going. Okay, go to the next page. So further, the trail was portrayed as a complete new surface, like a fairway in the golf course, fairway, fairway, absolutely flat. The jury believed that the bush or brush did exist, and the plaintiff was awarded $1.5 million, which means this case, this accident occurs in 1978, I think, the late 1970s. The final decision, the Intermediate Court of Appeals, was over in 1982. Think about the ski resort in 1980s, 1970s. Can you make perfect flat surface of a ski? 2015, there's all kind of IT equipment available, so we can do it very similar to that fairway. However, in 1970s, there's no way. And also, key phrases in this case was the novice skier. The plaintiff was not experienced skier, just beginning level of skier. So why he chose this ski resort? Because the marketing brochure says, oh, this is a completely new surface, and fairway absolutely flat. If I'm the beginner of ski, then probably I would do the same thing. Wow, this is the perfect ski resort for me, like me, as a beginner. But if I ski in this ski resort, then there's a bush or brushes concealed by snow. I couldn't see it because I never ski before. This is my first time or second time. I'm not able to recognize, I'm never be able to aware of that hidden bush or brushes, right? So this case, the defendant, this ski resort lost this case because of the marketing brochure. They uses complete new surface and fairway absolutely flat. If you said it, then your duty of reasonable care necessarily go up accordingly, because this is what you promise. If you fail to promise, then you will be liable. So you don't have to do it. You don't have to say it unless you have to. Okay, so exculpatory agreement, waivers. Examples of exculpatory agreement are waivers, or some people call it releases. Releases. If the fan or customer has to sign the form, then we call it waivers. But like a baseball stadium or the Disneyland, so if you buy the ticket, the back of the ticket actually indicate with very small size of font, potential danger, and then you have to give up your right. So that, if it's the case, then we call it releases. One-way direction. Releases is a one-way direction. Waiver is a two-way direction. Okay, I want you to read what's this activity about, and then if you agree, then I want you to sign it. And then please give it to me. That's the waivers. And then just if you buy the ticket, back of the ticket indicate potential danger of this activity, blah blah blah. Then we call it releases. We do not collect releases. The organization does not collect releases. So from the MTV's case, from the Korean, I kind of realized Switzerland, the bungee jumping rope, right? They change their bungee jumping rope every 300 times. And what about Korea? 900. So they replaced the rope of bungee jumping after 900 times. In Switzerland, 300. What do you think? Very dangerous, right? 3 times more dangerous to bungee jump in Korea than in Switzerland. This is based on scientific support, or we just said 900. I don't know exactly what happened. However, if it's the case, if they ask you or require you to sign the waiver form, they will be protected from waiver form as long as the waiver form is written correctly and uses in the right conditions. But they're taking advantages. Organization, extreme sports organizers, they over-utilizing or abusing the benefit of waivers. They're mistaken. Okay? Waivers not automatically protect unless they use it in the right condition or they write in a good way. So this is overlapped. Which comes first? There's two different legal areas. Negligence, right? We talk about tort law. 손해배상법, tort law. So without contract law, organization or employee will be liable. However, another law actually appears, which is a contract. Waivers, releases, agreement to participate form. All these forms are part of a contract. Because I ask you to sign your name and date. Two-way directions. Okay? So, under the principles of tort law, without contract law, defendants are held accountable or liable for tortious acts that injure others. Without waivers, you will be liable if somebody hurt. However, contract law over that tort law, which means defendants are not liable because you signed the waiver form. So when you have a two different law between tort law and 손해배상법 and contract law over the tort law. Okay. So waiver is one of the type of contract in which one party gives up his or her right to sue the other party. Once you sign the waiver form, which means you're saying, I'm not gonna file a claim against the organization for negligence issue. So altering the outcome that would transpire under the usual tort law principles. Okay. So it provides loopholes. Organization. Why we have to protect the organization? Some organizations said, if you do not sign this waiver form, you are not able to participate. I really want to do this. For example, bungee jumping, rock climbing, hang gliding, extreme sports. If you want to do it, it's required to sign the waiver form. If you do not sign the waiver form, you are not. They will not let you do it. Does it make sense? But if you sign the waiver form, then if you hurt, then you are not able to file a claim against that organizations. So that's based on your voluntary actions. So court upholding waiver gives precedent to contract law over tort law. So contract law over tort law. So organization, we love this kind of regulations. So two major criteria. Number one, context. Context, right circumstances. When you use waivers, you have to use it in a right way. Secondly, the content. The content of the waiver form should be written in a good way. So let's talk about the context first. The minority. So under 18 years old or 19 years old in Korean ages, courts are divided about parent-child relationship or giving up a child right to sue. I introduced this case before, very briefly. If your mom, if mom of minor child signs the waiver form, which is give up the right to sue against the defendant, And then is it reasonable to do it? And one of the case, the victim, 15-year-old high school student, he went to ski resort and his mom signed a waiver form on behalf of her son because her son is a minor, not able to sign the contract, right? So he became half blinded. So file a claim. The court said, oh, you signed the waiver form, or the content was right. Context was right because the student, 15-year-old student, signed the waiver form and mom signed also. So which means you as a participant and your mom, your parent, understood potential danger within this activity, which is a skiing at this resort. So the ski resorts are not responsible for any potential dangers or, unfortunately, your son, being blinded. But Supreme Court brought up this issue. Truly, the mom, the parent, or legal guardian can give up the right to sue the defendant party? What do you think? Parents, I'm the one, I'm 15 years old, I'm blinded. Think about the worst case scenario, blinded both eyes by accident. I'm just 15 years old, I have to live more 60 or 70 years with blinded. But my mom just signed the waiver form on behalf of me. Because my mom signed the waiver form, I never have any chance to file a claim. Do you think parents can have that kind of right? What do you think? That's a more philosophical question rather than legal cases. So, in the United States, some states believe that parents cannot give up the right to sue the other defendant party on behalf of their minor child. Some states believe that parent can give up the right to sue the other party. So states are divided in terms of this decision. Okay, so let's take a look at Cooper and Aspen cases. Okay. Cooper and Aspen cases. So this is a Cooper case, Colorado. 1995, David Cooper, age 17, suffered injuries including blindness when he lost control and crashed. I'm sorry, he was 17. I said 15. Crashed into a tree while training on a ski race course. Both David and his mother had signed a release of liability prior to injury. The trial court upheld the release and the appellate court affirmed, holding that the release was enforceable, which means valid, good, enough, against Dave, even though he was a minor when the release was signed and when the accident occurred. So holding, the Colorado Supreme Court, the highest level of court in state, reversed the court's appeals judgment and remanded the case to the trial court, which means the waiver form signed by David Cooper and his mother was not valid. So waiver form cannot protect the ski resort or defendant. So he brought up some kind of a philosophical issue. So I just highlighted. So I want you to read this case with rationale. A parent to release the claims of minor child for possible future injuries from a recreational activity. This was the first time the Colorado Supreme Court addressed this specific issue. Most of times, Supreme Court do not care as much about the sports event or sports related issue as much as the real crimes. Sport, right? Recreation activity. However, this is the first case to bring up the possibility or possible future injuries by using of waivers. So parents cannot make unwise decision on behalf of a child. What if every child believes that their parents should be reasonable and logical. However, some parents are not. They are not responsible. So they can make unwise decisions. So minor children will be maybe victims of that unwise decision. So Colorado Supreme Court concluded that parents cannot make unwise decisions on behalf of a child, which means the waiver form signed by the parent not valid. So same decision, we call it like a sister city, Utah State and Washington State. So 3 states do not believe parents can sign the waiver on behalf of their minor child. But same time, in same year, in 2002, the opposite decision occurred in Massachusetts State. 16-year-old cheerleader fractured her arm during a high school cheerleading practice. The student sued the city based on the negligence of a coach, the alleged negligent hiring of the coach. The city raised the defense of release signed by the student's father 3 months prior to the injury. The trial court granted summary judgment for the defendant city on the basis the release was valid. Supreme Court Judicial Court of Massachusetts affirmed, holding that release was valid. Same year, 2002, different state in Massachusetts State believed that waiver form or release form signed by parents will be valid. But more state do not permit the parents can give up the right to sue the other party on behalf of their minor child. Massachusetts is one of the few states. So I want you to keep in mind that parents cannot, generally speaking, parents cannot give up the right to sue the other party on behalf of their minor child. That's the more dominant than the other cases.